Welcome to Global Investment Voice, your premier podcast for diving deep into the world of investment migration. Are you dreaming of a second or third passport? Then join us as we traverse the globe, exploring the ins and outs of the US EB-5 immigrant investor visa, uncover the secrets of golden visas, and delve into the many residency and citizenship by investment programs. Each episode is packed with exclusive insights from top industry experts. Whether you're an investor, developer, or a visionary entrepreneur, we're here to guide you through the complexities of global investment migration. And who better to navigate this journey with than your hosts, the dynamic legal duo of this industry, Mona Shah and Rebecca Singh. Plus, hear directly from a lineup of global investment migration leaders. So, buckle up and tune in to Global Investment Voice, where your global investment journey begins and expands.
Hey Rebecca, with the surge of EB-5 I-829 denials being referred to immigration judges during this Trump administration, this is a topic we can't ignore.
Yeah, Mona, there's so much to discuss on this topic, and I say we just get right into it. Our guest speaker is one who needs no introduction, and he's no stranger to Global Investment Voice. John Pratt, it's good to have you back on.
Thank you for having me. I mean, it's an important topic and critical at this point, but again, thank you for having me.
Oh, thanks, John. It's been a tumultuous year, to say the least. But before we get any further, let's just quickly, for the guests who don't understand what 829s are, 829 is the third stage of, quite honestly, the most critical stage of the EB-5 process. And traditionally, we've been doing this 20-something years, and we have not seen denials on the scale that we are seeing. Right, John?
Yeah, correct. What happened is, put a little background, on February of this year, Trump also issued a memorandum saying that whenever you have a denial, they got to put people in proceedings. But I think out of that memorandum, also, there has been an uptick in I-829 denials for a variety of reasons. But, yes, the denials are occurring more often now on the I-829 context for a variety of different reasons. They're adjudicating them. And those denials are leading to people being placed in removal proceedings in front of immigration judges in a deportation removal proceeding context.
Yeah, you know what is so unfair here, though, is that USCIS themselves have taken 4+ years to get to these 829 adjudications. So if somebody is coming in, they're taking 1.5 years to get their original green card, then 2 years on the green card, then 4+ years. We're talking about people being here 7, 8, 9, 10 years. They've made a life, John, right, Rebecca?
Yeah, they've integrated themselves into the U.S. society, pay their taxes, and then if they get an I-829 denial, John, how do they maintain their status? We say they'll get an NTA, which is a notice to appear to go in front of the immigration judge. But in that time period, how can they stay? They can't stop working right away.
Correct. Well, the law basically establishes that a person's, when the I-829 is denied, they can renew that application in front of the immigration judge. So when the I-829 is denied by USCIS, there's no appeal from it, but there's a renewal that is permitted in front of the immigration judge.
But John, a lot of people are scared of the word immigration judge and deportation proceedings. I think it's really good to point out, to say that I will say to all of our audience that don't worry. Immigration judges are people. In fact, they're much nicer than USCIS.
Yes. Let me address the first question, which is, what is my status after USCIS denies my I-829? The same as I was before. I'm still a conditional resident.
Right.
Until when do I keep my conditional resident status? Until there's a final administrative order of removal. What is, or when do you get an administrative order of removal? That's when the immigration judge denies your I-829 or denies any other applications for relief and orders your removal from the United States or your deportation. You then have one administrative appeal to the Board of Immigration Appeals. That decision to remove and strip away your green card is not final. The appellate process, through the administrative appellate process at the Board of Immigration Appeals, you keep your green card. Now, what does that mean? You keep all the privileges and rights of green card.
But John, I don't know if you have noticed, though, we have been seeing this since this administration's come in. There is a different language in the denial.
Well, that language, Mona, it's what's in the statute. The language basically says that your statute's terminated. That's actually a tension that exists in the law because the actual INA in 216 says that. However, there's case law and other regulatory and other statutory language that indicates that your true green card status does not terminate until there's a final order of removal.
I agree 100% with you. However, in the language, in the notices that being sent out, it actually states that all rights and privileges which the petitioner derived from the status, including the right to work in the United States, are terminated as of the date of this letter. So if your people are panicking, they're losing their jobs.
Well, again, that's incorrect. And, I provided, the people that have hired me, I give them a letter that explains what the law is. Sometimes I met with HR, and a lot of them, at least I can tell you from the people I've been representing, no one has indicated that they lost their jobs because they get an I-551 stamp proof that they're continuing to be lawful permanent residents. And with the I-551 stamp that you continue to be a lawful permanent resident, then you satisfy your I-9 employment requirements and so forth. And obviously, the I-551 stamp is still documentation that you're a green card holder for travel and other purposes.
But John, to get that I-551 stamp, do they need to be in removal proceedings and get that NTA first, or do they automatically get that? How do they maintain that status from that date they receive that denial?
A lot of people that have had I-829s, they've had it for a long time. They get I-551s or by USCIS. You can continue getting those I-551 stamps with USCIS, whether you're placed in removal proceedings or not. So you can continue getting your I-551 stamps if you're not put in proceedings. Even if you're put in proceedings, you continue to have your I-551 stamps. What happens sometimes when you're in proceedings, that they will only give you the stamp valid to the next court hearing date. And then at the next court hearing date, if you get a new court hearing date, you will get a new stamp to the next court hearing date. There's been, again, the clients that have hired me, I give them a letter that explains that 95% of the cases get resolved without letter speaking to a supervisor. There's been a few cases where the supervisors or the people at USCIS believe or don't think that the person continues to be a resident, and we've been able to resolve that short of litigation. Let me say one thing that has become more problematic in the Trump administration era. Yes, you have the right to green card. What's the right to green card? Live, work, study, and travel. But international travel, and this is not to scare people, it's just fact.
Yeah.
International travel, when you are placed in removal proceedings, then becomes more dangerous or there's more risk. What is the risk? If you're a green card holder, the law says this, if you're any type of green card holder and you travel while you have a process to put you in deportation proceedings, you are seeking an entry when you come back and you may be detained, and you may not be able to be released on bond if the government doesn't want to release you on bond. So international travel becomes problematic once you're put in proceedings or risky. Because still 99% of my clients in removal proceedings are not having issues, but some are. And if you travel internationally, you may be subject to detention and no bond. The only other thing I would like to say is this. I have a lot of clients in removal proceedings with I-829 denials. Once you're in removal proceedings, you could be subject to detention. You could try to get out of detention and you could get a bond. But I have 3 clients right now who have been placed on what they call alternatives to detention. They were placed with ankle bracelets, and that can happen.
Oh, wow. So 2 questions here. One is that, and we get asked this all the time, when you have a project where there have been other 829 denials, but people haven't got it yet, is it safe to travel if the 829 denial could happen whilst you're away?
Well, let me answer it this way. And I had a case where there was an I-829 denial. The gentleman was a student at Harvard, and he was detained coming back from Logan. And they said, well, USCIS denied your I-829. You're no longer a resident. We're going to deport you. I filed what it's called a habeas. It's a federal court lawsuit challenging that determination and challenging that the person could be deported summarily. We succeeded. We were able to prove to the government that the person retained green card until there's a final administrative order or removal. And more importantly, we were able to prove to the government that although the I-29 had been denied by USCIS, the person had not been placed in proceedings while they departed. So when they departed, there was no proceedings commenced. There was no NTA filed with a court. That allowed me to convince the government that the person was subject to be released. If the person leaves while a removal proceeding has commenced, an NTA is filed with the court, the risk of being detained is greater and the risk of being released is greater, or not released is greater. So it's critical that if you have an I-829, you work with your lawyer to A, monitor when an NTA gets issued. B, if you got to travel, have proof that you left before an NTA, an immigration court had commenced. And 3, my advice is travel on a weekday. You don't want to come back on a Friday night. They get confused and you spend the weekend in jail. Come back on a weekday and work with your lawyer to ensure that if you have any issues, it can be addressed.
Now, my second question, going back to what we said earlier, is that we've never seen as many NTAs being issued. In fact, I think in my career of all these years, I've only seen one NTA issued post I-829 denial. Now they are coming so quickly. But people, I feel, are unnecessarily panicking in the sense that I do feel that immigration judges are humans, they're people, and that there is every opportunity that they will look at your case favorably. Do you agree?
The problem is, I'm not trying to panic people, but not all judges are created equal.
Yeah.
And what you're going to have is differences in different judges. And we can address this a little bit later on some of the relief. I had a judge that granted cancellation of removal. I have a judge in Santa Ana that says, I will permit all cancellations of removal applications on the spot.
Oh, wow.
So you have to preserve it for appeal. And what the Trump administration, again, is not to cause fear, it's just simply facts. The Trump administration has fired a lot of immigration judges.
Well, that's what we were just about to mention to you, right?
And a lot of the immigration judges that they fired were the immigration judges that were,
the nice ones.
Had higher approval ratings, or approval rates and some other types of relief from immigration, etc. And they have a plan. To, bottom line is, assign military judges to do immigration. Now, again, I think that these judges are going to be fair, but there's disparities in the immigration judge who you get. There's disparities in the prosecutor. And the bottom line is you just got to make and present the best case humanly possible to try to maximize the chances of winning in immigration court. But I'll go back and restate it, though. Why the surge on NTAs with I-829s? Because Mr. Trump issued a memo on February 28th of this year, that said that a lot more people have to be put in removal proceedings. And he singled out, among other petitions, I-485 denials, I-829 denials. What he instructed the agency is to no longer procrastinate, and as soon as they deny it, to put the person in a removal proceeding context. Let's also remember not to create fear. The big beautiful bill just awarded DHS, ICE, and the prosecutors over $40 billion to ramp up deportation. That's part of what's happening.
But I think, once they get that NTA, John, how long is this going to take in immigration court? I think a lot of people are going to get tired and frustrated through that process.
And the other thing is, we are dealing with people who've made their life here for sure. Mm-hmm. But these are also EB-5 petitioners a lot of them are high net worth individuals who have alternatives in different countries. Surely these are the immigrants that we need in this country also. And does that not make a difference, in your opinion, even in front of a military judge?
I would love to say yes, but the reality is no.
Yeah.
In removal proceedings, you could renew your application. If you could prove that the money was used and that it created the jobs, you could try to win it in a removal proceeding. You may have what is called cancellation of removal. If you have more than 5 years as a green card holder, more than 7 years lawfully residing in the United States, you may have other type of relief. I mean, I have some investors, for example, that their kids are joining the military and they're getting citizenship through the military service. I have other people that got married to U.S. citizens. The bottom line is, Mona, the fact that, let's say I was defrauded or my project failed because it just didn't perform well, immigration judges will issue removal orders because they cannot grant it based on equities or factors. There's an issue of when can subsection M, the investor protections, could be kicked in immigration. We're litigating some of those cases. But to answer your direct question, do I believe that an immigration judge could grant relief just because the person is a high net worth individual, owns an apartment, pays taxes, and a good guy? Based on those factors alone, it will not do it. If they can convince the immigration judge that the jobs were created and the money was used, yes, they can win. If they can convince them of other types of relief and you satisfy.
John, you just had a big win, though.
Mm-hmm.
But that's a cancellation of removal, Mona. A cancellation of removal, you have to have statutory factors. What is it? Green card holder for a minimum of 5 years.
Most of them are
7 years, any lawful status. But if you
Yeah.
get, for example, you got an I-829 denial and the investor's only been a resident for 4 or hasn't been residing in the United States for more than 7 lawfully, you don't have cancellation because you don't qualify under the law. And the fact that you were defrauded and the fact that you were innocent and the fact that all that will not matter.
Yeah, that's the only time when the adjudication of the I-29s having a longer adjudication time actually helps. You get to
Correct, in some
actually
cases,
get more
but
years.
what's happening now with the Trump administration is as soon as denials come in, and this is where, and again, I would caution people because a lot of people are like, I want my I-29 now and I want a mandamus. Is it wise to do a mandamus if it could be denied? And if you're denied under the 5 and 7 year rule for cancellation, I don't know. That's a decision you need to make with your lawyer. But bottom line is you need to then now, whether, there's some incorrect decisions. You could renew it in front of a judge, but you have to anticipate the complexities now that a lot of in EB-5 did not handle before, the complexities of representation and removal proceedings of investors, EB-5 investors with I-829 denials. By the way, there's other people being placed in removal proceedings, and I may be beyond the scope of this thing. There's people with concurrent filings, EB-5, that are being placed in removal proceedings because of one thing or another as it relates to the concurrent filing. So one of the reliefs, for example, that's available in removal proceedings if you have an I-829 denial. Again, what does the statute say? That cancellations available to green card holders if they've had a green card for a minimum of 5 years before you get the NTA file with the court, and a minimum of 7 years lawfully residing in the United States in any status. So, for example, we had a client who had been a lawful permanent resident, conditional resident, for more than 10 years before their I-829 got denied. So by the time that we went on an NTA in front of an immigration court, they had more than 10 years residing in the United States with a green card. So they satisfied the 5 and 7 year rule for cancellation of removal as a lawful permanent resident. What we argue with the judge is that statutorily, the statute allow them to seek cancellation of removal. What does cancellation of removal do? It eliminates the basis for your removal or deportation from the United States. What is the charge in a removal context if you are an I-829 investor? That your I-829 was denied, and therefore you should be deported because your I-829 was denied. Well, we successfully litigated a case in an immigration court in San Diego earlier this year, where we argue with the judge that because the person had more than 5 years as a green card holder, more than 7 years living in the United States with that green card, because they paid taxes, they were good people, they were innocent investors, they were defrauded in a project, that they qualified and were merited. They should have been granted the cancellation of removal, eliminating the basis for their removal, allowing them to stay in the United States, and allow them, more importantly than not, to get an unrestricted green card. We won that. The government did not appeal it. And within a few months, eventually, we got an unrestricted 10-year green card, which will allow them to become citizens. So we succeeded in at least one case, and we're litigating other cases such as that to try to in some cases, is the only avenue you have left if you have the 5 and 7 year rules satisfied.
So besides that, and like you said, you paid your taxes, you show good moral character. Mona and I did cancellation of removal way back in the days on other types of cases for those who didn't have green card, for instance. There you had to show extreme hardships to, U.S. citizens or other LPR family members. Is that something you have to show in this situation?
No, for LPR cancellation, there is no extreme hardship to any qualifying relative. It's a balancing of tests. I pay my taxes, I'm a good person, etc. One of the critical things that became in my case is that they were innocent investors. They were defrauded. They did not commit any type of fraud, because there's some case law for conditional residence in the marriage context where cancellation was not available, but in those cases, people committed marriage fraud. I was able to convince them. But to answer your direct question, do you need a qualifying relative? No. Do you need hardship to a qualifying relative? No. It's a balancing of factors, and if the positive equities outweigh the negatives, and the judge agrees with you that they're eligible to not only apply but be granted, then you could obtain it. Now, there's some judges. There's one judge in the court in Santa Ana that believes that cancellation is not available, but you have to preserve the issue for appeal. As I said in the beginning, you have your green card through an administrative appeal to the Board of Immigration Appeals. If you lose the cancellation in front of the judge, you got to put all your legal arguments, you got to put your application, you got to put everything in front of the judge to preserve that for possible appeal.
So at least there are options. And as you said, you've won based on the cancellation removal. We want to make sure that investors out there, it is, a lot of them are scared, but we want to show them that there are options and there are ways to preserve their green cards. So, John, I wish we could speak more on this, but thank you so much for joining us on Global Investment Voice.
Perfect. Well, always a pleasure. It's an evolving and important topic that is becoming more prevalent than ever. And, absolutely.
Thank you.
Thank you again.
And that's a wrap on today's episode of Global Investment Voice. A huge thank you to all our listeners for tuning in and sharing this journey with us. Curious about unlocking the potential of global migration and citizenship? Make sure to visit us online at mshalaw.com and globalinvestmentvoice.com. Dive into our extensive library of podcast episodes. Stay ahead with the latest in migration news by signing up for our insider newsletter. Don't forget to connect with us on social media. Find us on LinkedIn, Instagram, and Facebook to keep the conversation going. Remember, the insights shared in our podcast are for informational purposes only, so please seek tailored legal, financial, or investment advice where needed. Thanks again for listening, and until next time, keep investing smart and living well with Global Investment Voice. We'll see you on the next episode.